Ladies and gentlemen, good evening. Thank you for coming out tonight. I'm Dr. Chris Hammonds. I'm a professor of political science here at the university and the director of the Morris Family Center for Law and Liberty. I hope many of you were out today at the opening of our new flagship facility modeled after Independence Hall today. It's beautiful. And you're welcome to go in and explore it tomorrow. It'll be open from 9 to 5. The doors will be open, so you should go in and take a look. We have to thank for that the founder of our university and benefactor, who next month will be his birthday, and he will be 103 years old. That's Dr. Stuart Morris on the front row here, so thank you for coming here. Yeah. All right. Every year we do a faculty lecture series on some various topics. This year we're doing criminal cases that change the nation, and I hope you will attend all 4 of the lectures throughout the coming year. Our speaker tonight began his career as a patrol officer in 1977 at Houston Police Department. While attending law school at the University of Houston, he quickly moved up the departmental ranks, become a detective in 1983, and obtaining the rank of sergeant in 1986. After graduating from the University of Houston Law Center in 1987, he continued his work for the citizens of Houston and was soon promoted to the office of deputy director and served as general counsel for the Houston Police Department for the last 20 years at his time with the department. In 2005, he became general counsel for the Major City Chiefs Association, which is a professional association of police chiefs and sheriffs representing the largest cities in the United States and Canada, serving over 76.5 million people and over 177,000 officers. He has taught courses for law enforcement officers both in Houston and throughout the United States and Canada. He has been an invited guest lecturer for the United States State Department International Law Enforcement Academy and has addressed numerous state and bar law enforcement organizations. Please help me welcome HBU's criminal justice professor, Professor Craig Ferrell.
Thank you. Thank you very much. Here's your notebook. Well, thank you all very much for coming tonight. It is my goal to not only talk about a criminal case that changed the nation, but about the university a little bit. But I want to give you a little sneak peek of what's coming up, because this is a 4-part series. I had the honor and privilege, I get to open this up. Hopefully I'll open this up strong and we'll talk about the granddaddy of all the criminal justice cases. That's Miranda. It's a case all of you know about. You probably all think you know everything about it, but I promise there's something about that case that you don't know, and we'll talk about it tonight. Then please mark your calendars and come back on November 10th. Professor Tyler will be talking about a sexier case, Mapp versus Ohio and the exclusionary rule. You don't want to miss that lecture. So come listen to Dr. Tyler get sexy with y'all. It's going to be interesting. Then Dr. Hensey gets to talk about what he loves talking about, attorneys and the right to attorneys. And so he's going to talk about that in the spring, in February. And I was also given the honor to close this out. So I want to finish strong, and we're going to end even stronger, talking about a subject that is often very controversial, but is very crucial to your and my safety, and that's called stop and frisk, a tool law enforcement officers have. So I'd really like you to come to each and every one of those. Now, Dr. Hammonds has already given some special recognition to Dr. Stuart Morris, but I'd like to go and present him with a memento from the Houston Police Department where I used to work. It's our shoulder patch. I have no doubt he's not going to put it on a jacket and impersonate an officer. I'd like to give him a challenge coin that has the HPD seal on one side, and on the back side, the police's largest union in the state of Texas. And also something that one of my students is going to start handing out to you now, something for each and every one of you. It's a Pray for Police band that we'll explain to you in just a minute. So I would love for you to accept this if you would. Thank you. Now, Dr. Hammonds oftentimes explains the purpose of the Law and Liberty Center that Dr. Stuart Morris was so gracious in helping us start. But I'm going to give you a quick run through because it's part of what we're going to do here tonight. We're going to educate every one of you on some great cases that make this nation great, greater than any other nation on the face of the earth. So we're going to educate you. And in fact, the first little piece of education you're going to get is on those pray for police bands that are coming around. That concept is around the nation now. It was started here in Houston. About 15 years ago, a police officer attending church was talking with his pastor, and the pastor and other members of the church wanted to pray for him and bathe him with prayer. So he took that idea to his union hall, and yes, the police union is not always bad guys. A lot of times they're good guys. We are very fortunate here in Houston to have a very responsible police union. And what they said was, yeah, we'll support that. They made these little bands up, didn't know how popular it'd be. And to me, it's not hashtag pray for police. That's always pound for me. I'm in a different generation. So what you call hashtag, I call pound. But you can go to that and it'll tell you some information about it. But the most important thing was they teamed with KSBJ. It got some local news coverage. Before you know it, other departments were wanting to do the same thing. The union graciously shared their idea. Then we started having local communities. We started having large state agencies, and then it went national. And it all started here in Houston because of our godly heritage, even here in Houston. We're going to talk about our godly heritage. We're also going to support both the students, the teachers that are here, and the invited guests that are here, and we're so glad you're here. We're going to defend our American democracy and our exceptionalism. We're not going to make any apologies for it. And we're going to hopefully, God willing, inspire you to learn more about what makes our country so great and what makes criminal justice so great. So when I was asked to do a lecture like this, the quick question was, where do we start? And I want to start with one of the things that you may not know. If you had me for Intro to Government, you would already have this. But what makes our country so great, in my opinion, is the first 10 amendments to our Constitution, our Bill of Rights. And what makes those so extraordinarily special is it shows our nation's Christian heritage. We were founded as a Christian nation. Whether we remain one is up to you and up to me. Who do we vote in office? Are we going to stay a Christian nation or not? It's up to us here tonight. But bottom line, civil liberties are God-given rights. The government didn't give these to us. God did. God gave these civil liberties to every man, woman, and child. And that's another thing that makes our country so special. A lot of countries have rights that they give their citizens. But because we knew these were not rights that we were giving, but rights that we had because God gave them to us, we honor these rights for everybody in our country. For all of our citizens, for all of our visitors, whether they came in legal or whether they got here illegally and broke a whole lot of laws. We're still going to give them those criminal rights that are civil liberties. And very few countries, if any, around the world will do that. And we're going to be talking about one of those rights tonight, the Fifth Amendment primarily. So we're going to be going through that. Now, my goal for each semester, as is my goal for tonight, is I'm going to tell you a lot of stuff. Sadly, this ancient Chinese proverb says you'll forget most of it. Yep, but I'm going to do it. It says if I show you something, you may remember a little bit more. So as I'm talking, I won't always reference that, but you're going to always have something behind the screen. So you're going to see a little bit of what I'm talking about, which means you're going to remember a sliver more. But the way that you'll really get to where you understand something is you have to involve people. The sad part of that is I can try all day long to involve you, but the only one that can get you involved is you. So I'd encourage you all tonight to stay focused the whole night. Don't check your phones. Don't drift off like we're so often doing and looking at something else. We can all give this talk an hour. So just leave your phones in your pocket. If put them on stun mode. If you have to get a call, run on out. Emergencies do happen. I understand that. But try to focus and get involved, and you truly will learn something tonight. Now, before I jump into Miranda, a little bit more about what not only makes this country great, but what makes our university great. All the students here, and hopefully if you're a visitor, if you walk around campus, there's 2 locations where you'll see our 10 pillars. And those 10 pillars were also graciously donated by Dr. Stuart Morris. But for those pillars, we may not have a university. We wouldn't have what? we wouldn't have our new Law and Liberty Center. Why? Because back in the Great Storm of 1900, the worst natural disaster our nation has ever faced, where we lost between 6,000 and 12,000 plus people, Dr. Stuart Morris's father strapped himself behind one of these pillars, and those pillars to him meant life, his life. And with his life came Dr. Stuart Morris. And with Dr. Stuart Morris came him and a group of other men who founded this university back in the late 50s, early 60s. And with Dr. Hammond's vision, we have taken that founding to a whole new level with the opening of the Law and Liberty Center today. And so a lot of people, as your students, please thank Dr. Hammond when you see him. He had a vision, an inspiration, I think it was God-breathed, for this Law and Liberty Center. And his efforts, I can't understate it, are the reason we have this great building. Now, those 10 pillars, they also represent something else. The 10 Commandments. At least they do to me. They represent the 10 Commandments, the foundation of a lot of our criminal laws in the United States. Not all of them, but they had a significant role in our criminal laws. Now, those 10 pillars also represent two of our very best majors and minors we have in this university, which upholds criminal justice. We have both a major and a minor in criminal justice, and we have a pre-law legal studies degree. I submit to you there's not a finer degree or a minor you can get on campus. So no matter what your major is, you may be a future pastor, music leader. There are always good reasons to take criminal justice. Why? Whether you like it or not, somebody in your congregation is going to get arrested someday. Your ability to understand the criminal justice system will make you a better pastor, a better youth leader, a better mother, a better father. So what you're getting here tonight will translate in the real world. And I think you'll find that. Another thing, you say, well, is this new to the country? No, it goes back to our, in my opinion, best and clearly my favorite president, George Washington. In the Judiciary Act of 1789, our founding fathers of our country knew we needed order. They knew we needed someone to keep the order. So what did they do? They created the first federal law enforcement agency, the United States Marshal Service. So law enforcement has been an integral part of our country ever since. And when you walk around, one of the things to look at, it's in the, what is that, top, that's my right, your left, is the memorial plaque for those 10 pillars. Stop by and read it sometimes. You've all seen the 10 pillars. Let me just show you, how many have actually stopped and read the plaque? So I've got 1, 2, 3. Stop and read the plaque. It'll tell you a lot about why those are so special for us here at this university. But time doesn't allow me to stay on my soapbox. Let me get to the case. And I start with the case by getting to the Fifth Amendment. We have all, at one time or another, been exposed to the Fifth Amendment, if nothing else on TV, watching cop shows. So you could probably recite part of it, but let me just read the first little part there for you. No person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment by a grand jury. Now here's the part this case is going to talk about tonight. Nor be compelled to be a witness against himself, nor be deprived of liberty, and it keeps going. If you're in my class, you're going to have to know more than that, but that's enough for us tonight. We're just going to kind of get a taste of it. Now, all of you think you know Miranda.
But why do people have these rights? What do they mean for you if you're ever accused of a crime?
And well, that's what we're going to talk about tonight. We're going to talk about why you have these rights and why this is a case that changed the nation. Now, we're going to do that by going through it and talking about some key parts of any legal case. Now, this isn't a legal class. It's not a criminal justice class. It's a talk about stuff that I want everybody in ordinary life to understand. You're going to be exposed to cases all the time. I submit to you, if you can find out the information I'm going to put on the screen about any case, you're going to be far more better prepared to deal with that and know how it affects you. So the first thing we're going to talk about is the case itself. And this is one of the first points that I submit to you very few people actually know. It's not just about Miranda v. Arizona. A lot of people think that's it. It was actually 4 cases from all around the nation that the Supreme Court chose to hear. It was in these cases where in 3 of the 4 cases, they got a written confession, and in all of the cases, they got a confession to a crime. But in none of the cases were the defendants advised specifically of their Fifth Amendment or Sixth Amendment rights. And so the cases where Miranda v. Arizona, you're going to find out that was about a rape and a kidnapping. These weren't minor cases. In New York, there was a case, Vinegra, I'm probably mispronouncing it, v. New York, had to do with a robbery. Westover versus United States, 2 Kansas City robberies. And in California v. Stewart, you had a purse snatching and a homicide. So these were serious cases with bad guys that you don't want to put out on the street. We know what happens in Houston when that happens. Other people get killed. And so they all got convicted, and they're all appealing their cases. And the Supreme Court took the case, and they decided they were going to address a legal issue. But the next thing I submit to you that a lot of academics that have never been a practitioner look to is they go straight to the law, and they want to just talk about and focus on what's the law, what's the law. One thing you'll find out if you take one of my courses or Dr. Tyler's, the law is going to remain fairly constant. But what changes? The facts. And you're going to find if you change one little fact, the law doesn't change, but oftentimes the outcome of the case changes because the law is applied to facts, and not every case is the same. Then, on any case that goes to the Supreme Court will tell us what legal issue are they hearing the case to decide. They don't give advisory opinions. They don't just come out and talk to us because they want to talk. And then they're going to give a decision or a holding that it's called. And then the reason you're here talking about cases with us tonight is because they're cases that were significant then, which was 1966, and now in 2022. It's still a significant case that affects us. Now, Miranda is the best known, arguably most significant law enforcement case ever decided by the Supreme Court. It's been praised, it's been maligned, cussed, discussed, and misunderstood universally around legal communities and police communities. This particular case, in my opinion, is the only case that I know of that led to its own word that everybody in this country has heard. Mirandized. Did you Mirandize that suspect? You can't watch the local news at night, or you can't watch a cop movie or a cop show and not hear the word Mirandize. And you hear police officers asking other police officers, hey, did you Mirandize that suspect? That came from this case. And this case established a 3-question test to let us know if a confession gets to be used in court. The first part of that test is, were the Miranda rights given or read to the suspect? If you get that box checked, you still don't get to use the confession. You have to pass the next box. Was there a waiver by the suspect? And the third test was that waiver intelligently and knowingly and voluntarily given? And without that, you still can't use a confession to keep one of these bad guys in jail where they need to be. Now, I told you we have to focus on the facts and then understand the law so that we can truly understand the case. So to do that, this case is about Ernesto Miranda. Now, that's what he looked like years later when he got out of jail. I'll show you another picture in a few minutes. But let's get some quick facts that the court had before them. He was born in 1941 in Arizona, Mesa, Arizona. He had trouble with law enforcement from a very early age. It actually started in elementary school for Ernesto Miranda. His mom died early in his life. That's never a good thing. But his father remarried, and he actually didn't get along with his dad, his brother, or his stepmom. He first had a criminal conviction when he reached 8th grade. So he got to 8th grade, got a conviction. The very next year, he upgraded his crime to a burglary, and they sent him off to reform school. In 1956, 1 month after he got out of reform school, he was back in trouble again. He got busted by the police and sent back to reform school. When he got out the next time, he moved to Los Angeles, changed his luck. But within months of his arrival, he was arrested again, not convicted this time, but this time he'd upped his crimes to armed robbery and some sex offenses, some minor sex offenses. By the fall of 1957, he was a teenager who had been in prison for his third time, and he got sent back to reform school. He got out, and this time he decided, I'm going to join the Army, maybe things will be better. He joined the Army, and what happened there? 15 months, he managed to get himself dishonorably discharged, and during that 15 months, he spent 6 months in the brig doing hard labor for what? For a whole bunch of AWOLs and for some peeping Tom offenses where he was spying on other soldiers having sex with other people. So kind of a pervert from early on there, wasn't he, in a lot of ways? We'll call it like we see it in my criminal justice classes. We're not going to hold back on that. Now, he got out of there and he drifted through the southern United States. He has a connection to Texas. He spent time in some of our Texas jails. So he didn't follow our laws either. Then he left Texas, he went to Tennessee, and they busted him for driving a stolen car. He spent a year and a day in jail. Gets out of jail, and now it looked like maybe things were going to go better. He finally went a couple of years without any interaction with law enforcement, moved in with a lady named Tawilya Hoffman. She was 29 years old, a lot older than him. She had a boy and a girl from another man who she couldn't afford to get divorced from. But that was basically his common law wife or girlfriend. I'm not sure of the common law. It would be in Texas anyway. I don't know what it is in that state. But then that brings us to Ernesto Miranda and the facts. And all that's facts. And it's stuff the court does occasionally look at. But what were the big facts that the Supreme Court highlighted? They highlighted that he was arrested at his home in Phoenix, Arizona on circumstantial evidence. He was arrested there because his description of his car and part of his car license plate, where they got a partial but not the entire plate, matched his. That led the police to go there and do an investigation, which led to them taking him into custody. They took him to a police station for a rape and a kidnapping of an 18-year-old young woman. He was 23 years old, the court decision said, poor, a ninth grade dropout, a son of an immigrant, but a citizen. Clearly, everybody said he's not the sharpest crayon in the box. You know that. Now, the court, and this is a term they used then, said he wasn't incompetent, wasn't mentally retarded, but clearly wasn't that bright. He kept getting caught, for one, for all of his crimes, right? He was interrogated for over 2 hours. He admitted to raping and kidnapping this girl. He signed a written confession. They went to trial. They didn't need any more than that. They used that and convicted him, took the pressure off the victim to not have to come in and testify. He appealed it up to the Arizona Supreme Court. Everybody thought that was good because it was following the law at the time, which was if you gave a voluntary confession, that's all you had to have. But he appealed it to the Supreme Court, and the Supreme Court decided to hear the case for one central legal issue. There was a lot of things his lawyers didn't like about the case, but this is the only thing the court decided to talk about. Must the police inform a suspect who is the subject to custodial interrogation of his or her constitutional rights involving self-incrimination and counsel, so Fifth and Sixth Amendment rights, prior to the evidence that they get from him being usable in court? And so what did the court decide? What's the first thing you think the Supreme Court said? You all know it. What are your Miranda rights? Somebody shout it out. Right to remain silent, I heard. What's the next thing? Well, that's not the next thing, but that's correct. If you say anything, it can't be used against you. So you have the right to keep your mouth shut, but if you talk, whatever you say, cops can use. The other one was what your fellow student said, the right to attorney, and what's the last part of Miranda? There you go. See, everybody knows Miranda, but there's a lot that I know you don't know about this case. For example, you may not know that that is the floor that the Supreme Court set. Each state can give additional rights. Texas is a state that gave an additional right. They added this in our Code of Criminal Procedure. You have the right to terminate the interview, so you waive your rights, you start talking. You can stop talking at any point you want. So you still have those God-given civil liberties, we said in Texas, and you can stop talking. And you'll find that in most states, to my knowledge, in all states, they have either by statute or by further cases that came down the line after it, given a suspect these rights. But your Miranda rights are just the one in red. The fifth right is related to Miranda, but not part of the case. But since we're wanting to educate you, I don't want you just to get part of the decision. Now, this next quote is particularly interesting and to me kind of humorous. I was a detective for a number of years working felony cases. I interrogated hundreds of suspects, run hundreds of felony warrants. And I really, really wish this was true. The entire aura and atmosphere of a police interrogation without notification of a suspect's rights and the assistance of counsel tends to subjugate that individual to the will of his examiner. Man, it sounds like I'm the Superman. I can just by my questioning make anybody tell me anything. It doesn't work that way. Real life, let me tell you, is a lot different. There's some pretty tough folks, both males and females, that commit these crimes. Well, you got some youthful offenders, that may be true. But for the vast majority of criminals, I wasn't subjugating anybody to anything. And so that's a quote that, though, is in all the textbooks about this case. Not true in real life. Very often it's not true. What's the next thing about the case? What we just talked about. A new requirement for police officers. That was extraordinary, unique. Supreme Court never goes out and just tells the cops or the prosecutors exactly what they have to do. They uphold or overturn a case normally. And then it's up to the police, the attorneys, the DA's office, and courts down the road to actually flesh it all out and figure exactly how does that ruling work with other facts. Supreme Court wanted to make this one crystal clear. They told the cops exactly what they were supposed to do. And so what's the takeaway for law enforcement? Well, every police policy across the nation changed instantly. They all started writing new policies because you're wasting your time if you don't follow this decision. You can do everything you want, arrest all the bad guys, get all the evidence you want, but if you don't follow the rules, the evidence doesn't come in and the bad guy walks. So every policy in every police department all throughout this nation changed. So kind of brings this back to the case. You're getting the shorthand version. I go a little bit longer in more detail in my class. But I come back to the question, who was Ernesto Miranda? Well, that picture there with the Arizona State Prison was a picture of him a lot closer in time to when he committed the rape and kidnapping. And after he took his case to the Supreme Court, his case was overturned. But Mr. Miranda did not see the light of day. You say, how does that happen? Well, a lot of people think if you mess up, the bad guy always gets out of jail. Sadly, nowadays that's happening more often than I think it should. But nonetheless, what happened was the state of Arizona, as soon as he got released from prison, rearrested him on the same charge. He said, can they do that? The short answer is yes. If you take my class or Dr. Tyler's, you'll learn double jeopardy is not triggered by this happening. Because why? What happened? He was found guilty. If he was found not guilty, you could never retry him. It's like O.J. Simpson. He was found not guilty even though he probably did the crime. Never be able to retry that man for slashing his wife and her lover's bodies and throats and killing them. But guess what? Ernesto Miranda, he didn't get found not guilty. He was found guilty. He asked the court to correct a mistake. The court granted his request, corrected the mistake, said that confession could never be used, but the state of Arizona wasn't deterred. They said, we've got plenty of evidence on this guy. They re-indicted and re-arrested him, tried him again, and convicted him again. He got the same 20 to 30 years on each case that he got the first time around. Different than we do it in Texas. We wouldn't give that type of sentence, but they did that in Arizona. How did he get convicted? Well, I told you, he wasn't the sharpest crayon in the deck. He told his common law wife/girlfriend that he had kidnapped and raped a girl. Probably not going to keep her silent when she knows that, right? What else? The victim said, that's the guy that kidnapped and raped me. So it didn't take a lot to get a jury to reconvict him. So he was reconvicted, got the same sentence he got the last time, and was sent to prison. But then, after 9 years in prison, he keeps getting chance after chance after chance. They let him out of jail. He starts touring the country with the ACLU. And what did he do to make money? You see it on the right-hand side. The older people in the audience will know what I'm talking about. I don't see them in grocery stores anymore. They used to sell bubble gum cards where you had a stick of bubble gum and you had a football player, or a basketball player, or a baseball player. It had their picture on one side. That's Ernesto Miranda's picture on one side. On the other, it has the stats. Well, the stats on his card are what you see there, the Miranda rights that the Supreme Court gave. And for $1.50, he'd sign it. So you're seeing an autographed card there. And so he toured the country, but he still kept getting himself in trouble. He didn't really change his bad ways. So what did he do? He started getting a lot of driving and drunk charges, and so eventually he got his license revoked. Then he got arrested for possession of a gun. They didn't convict him of it. They just revoked his parole and sent him back to prison because he still had he had 11 to 21 years to go because he had served 9 years. And so what happens there, he does a year, they let him out again, he still doesn't change his way. And you say, how do you know? Because on January 31st, 1976, shortly after his release for violating his parole, they found him stabbed to death in a Skid Row card game. And now here's where you're going to have to take my class to find out if everything I'm going to tell you actually happened or is urban legend. One thing I'll tell you is a fact. On his cold, dead body, they found his Miranda cards that were autographed. And another fact is the suspects that had killed Ernesto Miranda had their Miranda rights read to them. Now, what you got to find out if it's urban legend or not by taking a class with me, did those cops take one of those bloody Miranda cards off his cold, dead body and read the suspect their rights right off of that card? We don't know. Come back, take a class, we'll talk about that. But that's Ernesto Miranda. So now we get to what did the citizens think about all this? What did the elected officials think? More importantly, when we think about that, what did they do, if anything? So how many of you think the citizens and elected officials supported this decision? Just raise your hand. So I got a few. So yes, you're correct. That's a correct answer. Some did. But the vast majority didn't like this decision at all. And the vast majority didn't like it. So since they didn't like it, what did they do? I'm sure some cried about it. But what they actually did was they tried to undo it. If you take Dr. Tyler a little bit more than me, he'll go into this subject. How do you undo a bad court decision? I kind of skip over that a little bit, and that's why we've worked together to have our 2 degrees kind of joined together, and synergistically, they're both better degrees because we're both here working together. But they've decided to undo it. So how did they do it? If you take my government class, you've already seen this semester. I may be the only professor in any college anywhere that shows Schoolhouse Rocks. But I show it to my students because it's a good learning tool. What did they do? They passed a bill, but it's a long, long way to Capitol Hill, it'll tell you. And so the question we're going to ask, did it work? If you're in my class, I'd actually play a little bit of that. We don't have time tonight to play that video. But did it work? Well, let's think about it. The political reaction was swift. We weren't divided as a nation on this. Republicans, Democrats, independents, all decided we've got to fix this. This was a crazy court. They passed in 1968 the ominous Crime Control and Safe Streets Acts of 1968 in 18 U.S.C. Section 3501. Many commentators at the time said that was the politicians' gesture of defiance at a Supreme Court which tended to protect criminals, communists, and attack traditional religious, political, and social institutions, and they said, we're going to undo it. Part of that act undid it because what the statute did in one little section was, it said if somebody gives you a voluntary confession, that's good enough. The old rule before Miranda was voluntary is what you had to prove, and they said that's what we're going back to. They couldn't undo Mr. Miranda's case, but they thought they could fix it going forward. And they tried. Were they successful? Well, we didn't know for 32 years. Why? Because I guess everybody followed Miranda or didn't have the guts to appeal it. But in this particular case, in the late 1990s, we had a federal case where Mr. Dickinson confessed to robbing a series of banks. They took a voluntary statement, took a bad guy off the street, except the trial court said you can't use the confession, so case over. But guess what? They appealed it to the Fourth Circuit Court of Appeals. Fourth Circuit said, hey, Congress passed a law. The law says you don't have to do it. That's good enough for us. But a year later, the Supreme Court, in a 7-2 decision in Dickerson versus United States, said Miranda announced a constitutional right. A lot of debate and argument whether that's accurate or not. But you know, all the debate in the world doesn't change the fact that when the Supreme Court says 7-2 that it is for now. It was from then. So you have a constitutional right. Therefore, only a constitutional amendment is going to be able to undo Miranda. So the federal legislative effort to undo this bad decision did not work, and it took us 32 years to find out it didn't work. However, I told you, these are cases that changed in America, and more importantly, still are. So just this year, the Supreme Court heard another Miranda case. Vega versus Tekoff, however you would say that, came out this summer. And what were they talking about there? Well, the Supreme Court was asked to look at what the Ninth Circuit out in California had decided, which is if an officer takes a non-Mirandized statement and it somehow makes its way to being used into court, they have now violated that suspect's constitutional rights and committed a civil rights violation that you could sue him or her for. Supreme Court looked at that. Thank goodness they had a different view. They said a violation of Miranda is not necessarily a Fifth Amendment violation. They said expansion of Miranda to give somebody a right to sue the police officer that was trying to do his or her job would provide very little benefit to criminal defendants and impose a substantial cost on the judicial system. A great decision for police officers, but more importantly, a great decision for you and me. The result of this is bad guys stay in jail and don't walk our street and re-victimize everybody. So a great case for the public. Miranda, I'm not going to cover this. It was a very significant case. What I'd really like to do is show you in the 20 minutes I've got left or so how this case has traveled through about 6 decades now. What has happened to this case and how has it affected our life? And every one of these decisions had an effect. In 1984, Brinkmeyer versus McCarty, it went to the Supreme Court. And the Supreme Court said, Miranda is required to be given to criminal suspects before you interrogate him in a custodial situation for all felonies, all misdemeanors, even petty and some traffic offenses. So I asked, what's left? But the court told us a routine traffic stop. Now the problem is if you're a future police officer, when you go to the academy, you'll have it drilled in your head. There is no such thing as a routine traffic stop. But the Supreme Court said there was, and actually I liked it this time. They may not know what they were talking about, but that's a good decision for law enforcement and for the public. Because what they said was routine questioning where you are asking somebody their name, their age, the date of birth, where do they live. That's routine. You don't need to Mirandize somebody, even if they're in custody, to ask them those type of roadside questions. Now, Pennsylvania, a little slower state, they didn't quite get it. And in 1988, you had a guy stop at a field sobriety test. He was answering some questions to the cop and then got arrested for being, DUI or DWI, however they classify it in that state. And he appealed that, saying, they used my statements where I told them I had 5 beers or however many beers he had, and they used that against me. And it went up to the Pennsylvania Supreme Court, overturned the conviction, said you can't do it. Supreme Court heard the case and said, you must not have been listened 4 years ago. We said routine traffic stops are not the type of police action that requires a Miranda statement to be given. So they reversed that bad decision and left that drunk driver in prison where he needed to be for a while. Now, a quick note. The Miranda decision legally is just a Fifth Amendment case, but it intermingles Fifth Amendment rights with Sixth Amendment rights. But what they tell you if you read this case, and if you're going to law school, is that the first two rights about you have the right to remain silent, not to make any statement you make can and will be used against you, that comes from the Fifth Amendment. But the Sixth Amendment guarantees you the right to a lawyer in some circumstances. You'll find not in all circumstances. You get a traffic ticket by a Houston police officer, you don't have the right to get an attorney provided for you by the city of Houston. Not required. So you have to go a little bit deeper. And if you want to learn about the Sixth Amendment cases, Dr. Hensey will talk about that in February, I think it is, in February. And those are some cases that I have my students take a look at. So then what comes up? Miranda has to be given, the suspect has to waive it, but the waiver has to be knowingly given. That's why they wanted to know, how smart was Ernesto Miranda? Did he have the capability of understanding those rights the next time or the next suspect? And if he understood them, did he intelligently waive it? So those are elements that have to be proven before a confession can be used. And the rule before Miranda is still in place. A lot of people think when a decision comes out from the Supreme Court, everything else they said about the case you don't have to look at. You're going to flunk Dr. Tyler's and my course if you do that, and law school, and you'll never get past the bar exam. Because it doesn't mean all the old rules go away. And they didn't in this case, because even if you Mirandize somebody and they give a knowing and intelligent waiver, if they did it because you had a pistol up to their head, it wasn't voluntary and it can't come into court. So the old rule still applies in part. So now we're going to get to where it's kind of fun, and we're going to test your knowledge a little bit. Here's it is. Let's see how we do. May only be waived intelligently and knowingly, that also has to always be voluntary. So all of these have cases attached to them. Can a valid waiver be presumed from a suspect's silence after the warnings? What do you think? No. Come on up and grab one of these. I won't give them out to everybody, but you're correct. Come on up. Run up. Then we get to the next one. Is a waiver that's given to the police when they say, thank you for participating. Is a waiver that a suspect gives to a police. He says, I'm only going to confess to this because God told me to confess. Is that a valid waiver? Is it knowing, intelligent? No. I'd always ask, throw him a lifeline. Yes. We don't care what your motivation is. It could be your daddy told you to do it, your mommy told you to do it, and God does talk to you. You have a conscience. He will sometimes tell you you need to clear that conscience. Court says that's fine. That's good. Is a waiver after a prolonged interruption valid? Now, this is a tricky question. It's also a lawyer's favorite question because it's both yes and no, depending on the facts. The law doesn't change, but the facts do, and depending on what the facts are, it's sometimes yes, it's sometimes no. The reason it's a lawyer's favorite question, you got to go to a lawyer to find out what the answer is, and they don't work for free. And so you're going to spend some money to find out this one. Is a waiver that a suspect has withdrawn. He waived his rights and he said, I changed my mind. I've got a yes and a no. It's yes, but there's a provision. So the yeses were correct, but you have to immediately stop. But anything that was said before he or she revoked their consent, good to go. You can use it in court and get him convicted with. But you have to immediately stop or you're in trouble. Is a defendant's understanding of Miranda and not invoking them equivalent to a waiver? I'll give you some facts and let's see if your answer stays the same. It may. It's not a trick thing. But this was a great case that just came out 12 years ago. Burgess versus Tompkins. It was a 5-4 Supreme Court decision. So some attorneys, some lawyers, more importantly, some Supreme Court justices agreed with the no. But was it 5 of them or was it 4 of them? And here's what the facts are. And I got to give my kudos to these detectives because I interrogated hundreds of suspects and I never had that kind of patience. I'm kind of a ADD type person. I get moving or I get bored. And in church I take notes because I get bored there too, even though I love my pastor's sermon sometimes. So I do things to stay focused, and that's what I told you to do. Stay focused, hang with me. We got a few more minutes. We've got 15 more minutes, so don't give up on me. We still got some stuff to learn. So, in this case, you got somebody that killed somebody. 2 detectives were interrogating him in custody. They read him his Miranda rights. Do you understand it? You ever play a game of stare somebody down and see who blinks first? This guy, he's looking down, looking away, looking at him, but he never opened his mouth. So they kept asking him questions. He kept his mouth shut. He did that for almost 3 hours. I would have stopped, I promise you, probably an hour, and I would have been done. So I got to give great kudos to these cops. And I'll tell you, it was very interesting. One detective said, I'm out of here, I'm done. His partner said, wait, I'm almost done too. But you know what? I got to ask this, whatever he called him, choice adjective. Do you even believe in God? And for the first time ever in that 3-hour interrogation, he said, yes, kind of insolent. Then they said, do you even pray to God? Yes. Did you pray to God for killing that person? Yes. Thank you very much for confessing. Now the question is, what did the Supreme Court think about it? 5 felt one way, 4 felt the other. I've got a no on the table. How many think the no is correct? They wouldn't let that come in. Well, not a lot of brave people, a few hands. How many think yes? Why? Because what? The Supreme Court's corrupt. Thankfully, not all of them. And I won't even say that. Scratch that from my tape recording. But no, that's not the correct reason. Give me another reason. Because why? He remains silent. That would mean they don't let it in. Why would they let him in? We've got a student saying yes, they'd let it in. I'm asking, why would they let it in? Was there a waiver? Was there a waiver? No, he hadn't said a word. This was his only 3 statements to the police. Yes, I pray to God. Yes, I pray. And yes, I prayed to God to forgive me for killing that person. So was there a waiver? I started off thinking you were going to be correct. It said no. I thought the Supreme Court was going to rule that way. In an amazing case of common sense, the Supreme Court fooled me, and what they said was, yes, it was a waiver. And you say, when was the waiver? When he opened his mouth and talked. Was it intelligent and knowing? Yes, he kept his mouth shut for 3 hours. He understood the rights. He exercised the rights for 3 hours. So when was the waiver? When he opened his mouth and answered. So there's no magic words required. So again, I ask, I'm going to go pretty quick. When must a Miranda warning be given? First thing is, if you're not in custody, you don't have Miranda rights. When are you in custody? Either when you're arrested or when you have your freedoms deprived in a significant way. They've said a routine traffic stop, your freedom is deprived, but it's not in a significant way. So you're not entitled to Miranda. So I ask, and by now you ought to be knowing, nothing is as simple as my questions, right? When must Miranda warnings be given? Whenever there is a custodial interrogation. What's an interrogation? Well, first time, when police ask questions that tend to incriminate you. Did you kill that person? Or why did you kill that person? That's an incriminating question. But also you'll find, in this case, which in the 8 minutes I have left, I'm going to skip it. This is such a great case. It's where the police didn't technically interrogate somebody, they thought. But as it turned out, they set up the functional equivalent of an interrogation when you had a guy in Des Moines, Iowa, murdered a girl named Pamela Powers. She was 10 years old on Christmas Eve. She goes to a wrestling match with her family where her brother is wrestling. She has to go to the bathroom, and in Des Moines, Iowa, nobody worried about letting their kid go to the bathroom by themselves back in the 60s. And what happens? She goes to the bathroom, or the 70s. She goes to the bathroom, and what happens? They never see her again. But somebody sees a certain individual, Mr. Robert Williams, who, by the way, had just escaped from a mental institution a little while ago, and he was living at the YMCA where the wrestling match was. They saw him carrying something to his car, and they saw skinny white legs hanging out from it. And statewide manhunt, they get the guy. On the way back, they start referring to him as Reverend. Don't answer any questions. We're not going to interrogate you. And one thing leads to another, and he confesses and tells him where the body is. I got to tell you the end of the story, even though I'm going to lose something else at the end. I've got to tell you the last part, because justice does prevail. He gets his case overturned because that was considered an interrogation. But in a footnote in that decision, the Supreme Court said that one justice said in a footnote to his opinion, that doesn't necessarily mean that the evidence, i.e. the body, could not be used if it would have been inevitably discovered by the police anyway. And in another case, they took note, the police did. They rearrested him, recharged him. They tried that judge's footnote suggestion, and it worked. And this sick individual that killed this young child was reconvicted, and he died in prison 5 years ago in 2017. I didn't want to leave you hanging on that. Now, we're going to go real quick. Do these require Miranda? Further questioning about the same offense after a suspect asks for a lawyer. Can you use that statement if they give the statement? It's kind of tricky the way I've got it. Do these require Miranda, and is any confession valid? That one is no. Can't use that one. How about further question on unrelated offense? That one's no. You've got the cases where the Supreme Court decided this. I'm going to skip past all of these just because I am running fastly out of time. A couple of great Texas cases. Not all cases are simple. This particular case right here in 1975, they gave a weird exception. I would never rely on it unless you had those exact same facts. And even then, I think they may change them on you. But let me quickly go through these, get to right toward the end, because I want to leave time for some questions. So you see, come take one of my classes. There's a whole lot more to know about Miranda that I'm having time to give you. But I'm down to about 7 minutes. And so Dr. Hammond said I get the hook, and I don't want to find out what the hook is. So I'm going to keep going, and we're going to get out of here real quick. These are common situations. When the officer doesn't ask any questions, do you have to give Miranda warnings? No, you're not interrogating them if you don't ask questions. During on-the-scene questioning, when you don't know who the suspect is, you don't have to Mirandize everybody till you find out who the suspect is. When the statement is volunteered, I've had this happen as a patrol officer. I arrest somebody for a crime. I wasn't going to ask them a question. I was going to let the detective do it. They get in the car and they said, I did it. I shot that person. Well, thank you very much for telling me. I didn't have to Mirandize them, and I can use that statement because I wasn't interrogating them. When asking questions during routine traffic, we've already said no. Number 6, in stop and frisk cases, no, but come back in March. There is a lot to know about stop and frisk, and I'll talk with you about that case. But because of time, I don't have time to play this one. I'm going to tell you, there is a public safety exception to Miranda. And like in the Boston bombing case, and the police didn't immediately Mirandize Mr. Chernaroff after he got out of the hospital where he was apprehended and shot. They didn't Mirandize him because they wanted to know, did he plant bombs in New York as well as Boston? They had evidence to lead them to believe he may have. Not required. Now, harmless error rule, got to save that for another day. I already knew I was going to be fastly approaching the end when I got to this slide, so I already was planning on skipping it. But now we get to the last one that I got to give you a tip of the day or a tip of the night. HBU has a lot of great classes, but the tip is you're never going to find 2 better electives to take than these 2 on the board. Government 2350-01, Introduction to Criminal Justice. You get exposed to police, courts and correction, and about 60 to 75 real-life jobs when you graduate from law school. A course every student should take, no matter what your degree is in. And then the one that I love teaching the most is criminal procedure, where we'll talk about cases just like Miranda and others, where we dig down deep and learn about it. So unless you're a nursing student that has 0 electives, everybody has at least 1 elective, or preferably 2. Take both of these classes. Now, a hint is, if you take my criminal procedure class, Dr. Tyler has a Con Law 2 class that pairs perfectly with that class, and I suggest you take his class as well. But that's only if you have 3 electives. If you only have 2, these 2, that's the tip of the day. Those are the best to take. Now, sorry, Dr. Tyler, but to help Dr. Hammonds out, we never get an accurate head count. Whether your professor wants you to scan the QR code or not, scan it. And if you're a visitor, scan it, let us know you were here. We'd like to get a head count from you. We're not going to send you all kinds of mailers. He may send 1, I don't know. Any? No? So send that, and come back, hear Dr. Tyler in November, hear Dr. Hensey in February, and definitely don't miss March 23rd when I'll end this series talking about stop and frisk. What is this up here about? Go buy it at the bookstore. If you're in my class, you're going to find out, save your receipt, because I'll give you 5 points extra credit for helping get the word out. This is probably one of the most hidden majors and minors we have. Students don't know we have it. You do now. Buy the shirt. I don't get any royalties from it. And save your receipt. If you're in one of my classes, you get 5 points extra credit for helping support the program. If time allowed, I had some other goodies to give away, but we don't have time, so thank you very much. I'll let Dr. Hammond see if there's time for any questions.
Thank you, Dr. Ferrell. If you are a student here, make sure you log in on the QR code. That's how we're tracking your attendance if you're here for a class or for extra credit. We have 3 minutes, so maybe we have time for 1 or 2 questions.
Got 3 handouts, so let's get them.
Oh, there's one here.
Okay, ask it away and come on up, because I'm going to give you something for asking it. Just start walking up and asking.
It's a $100 bill.
Or less. Go ask your question. We don't have time for you to get up here, so ask it right there at the mic.
All right, so I'm curious on why Miranda was able to get out of jail so many times. Didn't they have strikes back then?
Not every... First, let me give you this. I got to get away from that microphone or nobody will hear me. The answer was, why did he get out of jail so many times? Because we're a Christian nation. We still have men and women of faith in this country that think people have an opportunity to change. Believe it or not, law enforcement, prosecutors, judges, they want to give somebody a chance at rehabilitation. But what you'll find, the only real change comes if you accept Jesus Christ as your Lord and Savior. And if we get that in the prisons, we're going to start doing a better job. And we started it here in Texas a few years ago. Time for 2 more quick questions.
Yes,
Quickly. Yes, ma'am. The short answer, was this the first time anything like this had happened? The answer is no. But it was the first time that the Supreme Court chose to take that issue up and hear about it. There was actually, like I said, 4 cases that happened at the same time that were working their way up to the courts. They heard the case and they decided those 4 cases. So there was at least 4 times, but I can tell you it had happened a lot before. It's just the first time the Supreme Court decided to decide the case and issue an opinion. One last question and you get a blessed are the peacemakers. Yes, ma'am. What made me want this to be a career? Short version is, I watch a lot of cop shows too. This is going to date my age. I love Starsky and Hutch. I didn't want to be a police officer in uniform, although I had to do that to become a detective. I always wanted to be a detective and solve crimes and really make a difference. And I got the opportunity and the privilege of doing that. I would have done that my whole career, except it doesn't pay as good if you stay at that rank. You start promoting, you start getting paid better. And I've always kind of looked the long road. I wanted a pension. I wanted to do something else. And every job I had, I also spent 3 years at the city attorney's office handling civil rights litigation for the city. And so God has just honored me and blessed me to be in all facets of criminal justice, except corrections, and that was a blessing too, because I don't like corrections. I actually worked in jail for a few months, and I hated it. So I worked in the police and the courts. And the beauty of coming to HBU, you don't just get an academic education. There's nothing wrong with that. Most of our professors are pure academics. They were the straight A's all the way through. I was a practitioner who became an academic. And when you take my class or you take Dr. Tyler's class, you're going to get not only the academic answer, but the real life answer about how does this work in the real world. Very few universities give you that opportunity. Take advantage of it while you're here at HBU.
Thank you, Professor. Thank you. The mic's on. Thank you, Dr. Ferrell, for your time. Thank you, ladies and gentlemen, for coming. We hope we will see you again at the next presentation. You're always welcome to come up and ask more questions, and when you leave tonight, there will be refreshments outside. Thank you, and have a great evening.